I may have to leave a little bit early today, James. Is that okay?
You won't hear me complaining, Professor.
No, I suppose not. Okay, let's get started. Restrictive agreements, or conspiracies, as our erstwhile American cousins like to say. What can you tell me about them?
A restrictive agreement under EU law is any agreement or concerted practice between undertakings that distorts competition and has an anti-competitive effect on competition within the EU.
Okay, and is a conspiracy the same thing as a restrictive practice?
I don't know for sure, but I suspect that basically it is. Perhaps the term conspiracy is broader as it does not expressly refer to the existence of an agreement. However, even if these two terms define the same basic notion, that is not to say that they have been given the same interpretation by the authorities in each jurisdiction. Perhaps the difference is above all linguistic. For example, competition law in the US is called antitrust law, referring to the form large business monopolies often took at the time of the adoption of the Sherman Act. In the same way, competition law is referred to as anti-monopoly law in China and Russia, I believe.
Really? I didn't know that. Are you sure?
Well, that is what I understand to be the case. You know, I did a 6-month work placement in Shanghai last summer working with a large Chinese law firm.
That's right. So you did. How was it over there?
I loved it, and I hope to go back if I can. It is a very interesting place, and the Chinese are very dynamic. Well, in any event, I worked on a file involving an agreement between a Russian buyer and a Chinese supplier. The negotiations were carried out in English, and the word they used generally for competition law was anti-monopoly law.
Okay, but interesting as that is, it's not what we're meant to be discussing today. So, if every country has competition laws, is there anything special about EU competition law?
In general, or in the context of restrictive agreements?
In the context of restrictive agreements?
Well, I guess the EU exemption regime is pretty special.
Do you mean other countries, such as the US, do not have an exemption mechanism?
Well, I am far from being an expert on US or indeed EU competition law, but
I never stopped you before, James.
no, it didn't, did it? But going back to what I was saying, in the US, exemptions are based either on specific laws and legal provisions or on court rulings. The European Union approach to granting exemptions is through administrative actions by way of individual or block exemption regulations adopted by the Commission. These exemptions can be restricted in time and can at any moment be reviewed and amended by the Commission itself. In the US, laws have been adopted exempting certain industries from competition law rules, such as sports, for example, and so the National Football League legally operates as a monopoly.
That sounds pretty expert to me, James. Good answer. And can you give me an example of an exemption in European law?
Any of the block exemption regulations, for example, the block exemption regulation on vertical restraints.
Very good, James. Okay, I have to go. I will try to do some extra time with you next week when we're going to be discussing dominance and merger control, okay?
Sure, no problem, Professor. See you next week.